complaints that existing staff could not do what Congress asked. Instead, the Immigration and Border Control staff was reduced. Now, the curious thing is that the very congressmen who most wanted exclusionary immigration policies were the ones who voted the most consistently to cut funds for immigration control. It should not, nothing surprising. Politicians are nuts, if nothing else, and inconsistent and contradictory. So what was going on? There was strong corporate support for food and drug and for conservation. There was not much corporate support for military or immigration, increases in the military or for immigration control. So congressional votes reflected where the money was, then as now. There was also, as one historian, John Bodner, I think you're reading one of his articles, but this is another piece of work that he did. He was looking at what he called the conflict between nationalists and patriots in the United States in the first half of the 20th century. The people with the most chauvinist, the most jingoistic, the most xenophobic rhetoric were those who most disliked the nationalization of the economy and of the government and wanted the economy to remain local. And he refers to those as the patriots. They confuse the country with Muncie, Indiana, or Stockton, California. For them, the country is where they can drive in a day's time. That's their United States. And they don't want a federal government they didn't want a federal government that was bigger than that. They were not like Theodore Roosevelt, who wanted a strong national state and hence faced opposition from many local conservatives. The regulatory state grew much more robustly at the state and municipal levels, where there was licensing of businesses, licensing of medical providers. In 1895, California passes one of the first laws in the country that determines who can be a medical practitioner, how much education you have to have, what kind of tests you have to take. Prior to 1895, anybody with a sign could say, I'm a doctor or I'm a dentist. And again, it was a customer beware. If the doctor if you didn't think the doctor or the dentist knew what they were doing, you wouldn't go to them, or you would talk to your friends. But the state said that wasn't enough. The state of California, we're going to have a state regulatory agency that's going to ensure that everyone practicing medicine has a basic level of training and is able to demonstrate skill competency. The states set up their own food agencies. They passed more intensive land and zoning laws determining what could be built where and when. There was increased use of eminent domain, which is when the state says it needs a piece of land in order to do something, in order to achieve economic development purposes. There were state public works, like building of dams. There was the government takeover of water, electricity, transportation, and also state mandating for fluoridation of water in order to have mandated dental prevention. The states built roads, and they developed the laws that regulated the roads, and they developed the standards for road safety. The states were largely responsible for the regulation of labor conditions, something the federal government had nothing to do with until 1936. The state governments were also heavily involved in social welfare issues. They set up children's bureaus, which preceded the federal children's bureaus, and they were much more actively engaged in following the policies that each of the states enacted, which of course were going to be quite different relating to child labor. Public health. The state of California was one of the first states in the country to mandate vaccinations, that you could not opt out of being vaccinated. And of course, education. At the beginning of the 20th century, you have the state beginning to require children to go to school for longer and longer periods of time. So by 1920s, in most states, 8 years of schooling was mandatory, with some exceptions for the children of agricultural workers, who, as always, the agricultural workers are the ones who get screwed in the way the economy is being structured. And there was, and the state laws included regulation of private schools. In 1912, further state action, and this was all done at the state government level, based after a study of medical schools, states began passing laws setting standards for medical education, and 2/3 of the medical schools in the United States were closed in the following 2 years by state action. So you don't need a strong federal government in order to have a strong state. What you have in that case, though, is at that time in 1912, 48 different sets of regulations. The United States Supreme Court emerged by the end of the 19th century as the most stable and, to some degree, the most powerful branch of the U.S. government. The Supreme Court, in a number of cases, articulated principles of nationalism, substantive due process, and they constitutionalized private contracts. The latter point, the constitutionalization of private contracts, is probably the most important. And this didn't happen all at once. There were a series of cases. But previous to, say, the 1880s, contracts between two individuals were private matters, which, if they were to be adjudicated, would be adjudicated on the state level only. The Supreme Court got involved when problems developed, when contracts are when one state was being asked to enforce a judge's decision regarding a contract that was rendered in another state. And the Supreme Court, instead of just ruling on the specifics, started developing a doctrine, which is that contracts between two parties have a legal standing in every part of the United States, and that every court has a responsibility to enforce that, to help those contracts be enforced. Because if there's no faith involved in private contracts, then there can be no faith between people engaged in any joint activity. So this is actually, oftentimes it's talked about the Supreme Court defending property rights over democratic rights, but really what they were defending was the sacredness of contract rights. And under that guise, the Supreme Court, the U.S. Supreme Court, became one of the primary obstacles to reform, social reform. It struck down pretty much all laws limiting child labor or regulating the hours that anybody could work, on the basis that these were contractual agreements that an employer or employees had agreed upon, and no government had the right to intervene and abrogate an already existing contract. In other words, not only did the courts have the obligation to enforce contracts, contracts trumped state action. So you have We'll end today with this double motion, a beginning of an increase in federal and state regulation of society, but the courts also saying that private contracts have a special place in national law and have to be protected almost at any cost, unless there were compelling public interests at stake. So we'll continue on next Monday. Have a great weekend.